Hear ye, the Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is Parks v. State of Florida, number 2023-1355.
Good morning. May it please the court, my name is Lori Wilner, and along with my co-counsel, Catherine Lane, I represent Mr. Parks in this case. I would like to reserve 5 minutes for rebuttal. Your Honors, the holding in Parks from the first DCA runs contrary not only to the plain language of the text, but also is opposed to the analysis by this court in Richards. It also goes against the presumption that we have that the legislature adopts the historical interpretation that's in place at that time, and that being that a request is required from the state attorney in order for the trial court to impose the cost of prosecution.
But hasn't the statute been changed in the intervening period? And how can you rely on a prior interpretation when there's been a pretty dramatic change in the text of the statute? That kind of puzzles me.
Well, Your Honor, my answer is twofold. One, it's the plain language of subsection 1, which has not been changed and has been interpreted the same way throughout history, including by the first DCA in Hills, and now suddenly in Parks, the first DCA says.
But the whole context changed. And one thing we know, if you've read our precedents lately, is that we don't look at, and I don't think this is limited to our recent precedents, but we don't look at language in isolation. We certainly look at it in the statutory, the immediate statutory context, and we would certainly look at it in the context of an amendment, changes to the statute that were made at the same time, and we couldn't understand it without looking at that. Isn't that correct?
That is correct, Your Honor. So what I can do now is just jump to the place where the amendment was made, and that's subsection 8. And in that subsection, the legislature said that the cost must be set in all cases at a minimum of, cost for the state attorney must be set, $50 for a misdemeanor, $100 for a felony. Let's compare that to the language that the legislature uses in the section that they call mandatory costs in all cases. As you know, this chapter 938 is in discretionary costs. If you look at the language in the mandatory costs, like 938.01, 938.03, all of those say, require every person to pay, shall be imposed, shall be levied. And yet, subsection 8 doesn't say any of that. It says must be set. And why does it say that? Because we have to read subsection 8 in conjunction with subsection 1.
But the verb for me is the key. You're right. The statute elsewhere talks about levying. It talks about imposing. Setting is a purposeful legislative choice. It could have said levied here. I read that as determined, like fixing the cost. The operative verb is different, and it sort of goes to the fact that a cost can be set without being levied. It could have said must be levied, shall be levied. That choice is not here. So how does the text support your, I would argue, conflation of setting a cost or a charge versus levying it, where elsewhere in the statute we see other choices?
Well, Your Honor, I might agree with that if we read subsection 8 by itself. it might just be the legislature decided to say set rather than levied.
They didn't do that by accident. That's not your position, is it?
No,
Okay.
not
so
at all.
why did they make that? What do we infer from that purposeful textual choice?
From that, I'm sorry, Your Honor. What we infer is that it must be set at those amounts when the state attorney requests the cost of prosecution as required in subsection 1. The intent of the legislature in amending this chapter to begin with was not to do away with the requirement that the state request the prosecution, but rather that the trial judge no longer determines the amount that the state attorney's fees would be. And there's a minimum set. That's a floor. The costs aren't mandatory in subsection 8. They're not mandatory. The amounts are mandatory if the prerequisite from subsection 1 is met.
Let me take you back to subsection 1, looking at it in context here, to the phrase that is at the end of the first sentence, if my blurry eyes are reading this correctly here this morning. And I'm talking about the phrase, if requested by such agencies. Now, when I read that in this context, I'm thinking, well, what are the such agencies? Yeah, typically that would be pointing back to something in the immediate context, some agencies. And I don't see the state attorney in that context. I see some other agencies. I see law enforcement agencies, fire departments, Department of Financial Services, Office of Financial Regulation, but I don't see any reference to the state attorneys. So when it says such agency, I'm not even sure that supports your argument, because if you look at it and if you look at that reference, I don't think you can read that as referring to the state attorney, because they don't fall within the ambit of such agencies.
Your Honor, I disagree.
Now, I don't know that that's ever been pointed out here, but
I'll be glad to address that. But I disagree with that argument for two reasons. One, it says for the payment of the cost of prosecution, including blah, blah, blah. If the legislature didn't want to include all of the cost of prosecution, why wouldn't it have said that? Or why?
But the request, what's being talked about here is a request by such agencies. And you're hanging your hat on that when I just don't see that the reference to such agencies can be understood as a reference to the state attorney.
Your Honor, I disagree, because the
I
state
thought you would.
The state has never argued that the state attorney's office is not an agency, and it certainly has never argued that the state attorney's fees are not a cost of prosecution. And in fact, the only definitions that I know of the state attorney's office are that it is an agency.
Well, but I think this all hinges on what's requested. And your argument is it has to be requested. And what this is saying is it has to, the requirement that it be requested, at least in this context, is limited to, it seems to me, to such agencies, and I don't read that. Now, I'm not saying if the state attorney asks for $10,000, they don't have to request that.
No,
I'm not suggesting that, but I think this is a complicated statute, and I just think there are elements of this that can pretty strongly cut against your argument.
I think, Your Honor, that this is statutory construction 101.
So if we take that and if we're looking at sentence structure and we see if requested by such agencies as a restrictive clause, you're saying it applies to the entire preceding language, then by that logic we'd be able to remove this including investigative cost clause and the sentence would still make sense. But if we do that, then it says are liable for the payments of cost of prosecution if requested by such agencies. And to Justice Kennedy's point, now the sentence doesn't operate correctly because we have a look back to such agencies without reference to any agency at all.
I see
so
that.
So why would we not use that as sentence structure?
I think for two reasons. One, because I think that the request is referring back to cost of prosecution, and two, this subsection has been interpreted the same way for decades, including by the first DCA. It's only in Parks that they suddenly decided that it says what Justice Kennedy says, which
Well,
is...
it hasn't. I mean, Parks pointed out that other district courts have also interpreted it as a mandatory cost without the need for request.
That's correct.
There isn't a uniform interpretation.
That's correct that they considered it to be a mandatory cost because of subsection 8. But my argument to that is it's not a mandatory cost. The legislature told us it's not a mandatory cost. It's a discretionary cost. When does it become mandatory? Only if a request is made.
Well, counsel, can you compare this to also in the discretionary section, the public defender cost?
Your Honor,
The statutory language is very similar.
it's similar, Your Honor, but to my knowledge, there has never been a requirement of a request by the public defender's office, other than usually the client will fill out an application to get the public defender's fees. But it's never been required of the public defender's office to request those fees. So in that case, I think it's clear that there's those minimum amounts that the trial court will set if the prerequisite of a public defender's office services are used, then it must be set at those minimum amounts. That's why that can't be in the mandatory section of the statute. I don't think that the first DCA can rewrite this entire chapter and say, oh, the legislature needs to move this over to the mandatory section. We'll do that for them. We'll say that the cost of prosecution, the state attorney's fees, are mandatory at this minimum amount. Well, that's not the case. Only those amounts are mandatory if a request is made. The imposition of those costs are not mandatory without a request, both on the plain language of this statute and the very strong presumption that the legislature adopts what's happening at the time it makes amendments. So it also amended Section 2A in this chapter, which just says that the trial court no longer takes into consideration the ability of the defendant to pay. It said several things here. It did not change subsection 1, which has always been interpreted as acknowledged by the state and the first DCA that historically been interpreted to require the state to request the cost of prosecution.
Why, once the legislature, though, sets the minimum amount, does the requirement, does it make sense still? I mean, I understand if something has to be proven, and it seems implicit that if you're going to go over the 50 or 100, that it would have to be requested. But once we know the legislature wants these defendants to be on the hook for the money, and then they give you this sort of default amount, does the rationale for the request go out the window?
No, Your Honor, because we have to remember the reason for setting those or setting a floor, a minimum amount, is because prior to this, the trial court determined the amount. And I do agree with the state that investigative costs vary so much that the legislature can't really set a minimum amount while they can for the state attorney's office. So they have set that minimum amount as long as the state requests it.
And why would a rational legislature, having set that sort of default, why would they, knowing that they want this money to be owed, why would they leave it to whether the state attorney asks for it or not?
Because that's the way that the courts have interpreted it throughout time until subsection 8 was adopted. But if you were writing on a blank slate, what reason would the legislature have for doing that? Because subsection 1, it's set. You have to ask for the state attorney's fees. How much should they get? Well, let's set that at a minimum amount. A minimum amount is set for the public defender's fees, and the only requirement there is that the client use the services of the public defender. All of these costs in this section under discretionary costs have some type of prerequisite. I think the section, the FDLE charges, that's one of these. In that subsection, it's interesting because it's discretionary as written unless a local lab is used, and then it becomes mandatory. But it's still part of this discretionary cost that the legislature has written. I could have written it differently. We all could have written it differently. I think subsection 1, if you want to say cost of prosecution except for the state attorney's fees, which will always be such and such, that's fine. But I still think we reach the same result by having subsection 1 and subsection 8 and following this court's analysis from Richards and reading the whole chapter together, all the paragraphs, all the clauses.
I'm glad you brought up result. If we decided to remand this case, would anything prohibit the state from requesting its costs on remand?
I think this court's opinion in Richards does, although, as Justice Kennedy pointed out, sometimes this court changes things, but at least in Richards, it said that the way the statute is written, the cost must be requested prior to the judgment being rendered. So I don't think the state can go back and request the cost of prosecution if this case is remanded for that reason. And I think that's clear from the language and this court's analysis.
There are DCA cases on that too, right? Related to the cost of investigation on remand?
Yes, Your Honor.
Can you explain the next sentence in Section 1? It would seem odd to me that if costs are imposed only when requested, that the next sentence, the court shall include these costs in every judgment rendered against a convicted person.
That's interesting, Your Honor, because sometimes the state will point to that. The state will say that the language of subsection 8 sounds mandatory because it says set. Well, that line there, the court shall include these in every judgment, that's clearly mandatory language. But as this court said in Richards, we cannot read that line without reading the rest of subsection 1. So it's clear if you want the cost of prosecution to be imposed, you request them, and then they must be included. At that point, it's not discretionary because the state has the discretion whether or not to request the cost. If they ask for them, they get them. If there are no further questions, I'll reserve the rest of my time for rebuttal.
Thank you very much.
May it please the court, my name is Julian Markham and I represent the state of Florida. The source of the conflict between the first and the second districts is the second district's reliance on an interpretation of section 938.27 that preceded its 2008 amendment. In this way, the second district has construed the statute's meaning by looking at subsection 1 in isolation, and because it did not consider the context provided by the different parts of the statute, it missed the change in the meaning following its 2008 amendment. If I may just jump ahead a little bit and address what was discussed a few minutes ago. In the abstract, someone might be unclear about which antecedent, if requested, applies to in subsection 1. Does it apply to the cost of prosecution, or does it apply to investigation costs? But subsection 8, and in particular the language in it that provides that the cost for the state attorney must be set in all cases, makes it clear. It makes the meaning clear because the legislature wouldn't have said in all cases if what it really meant was in all cases.
Well, there I have the same question for you that we
Sure.
discussed with your colleague about the different verb, set versus impose. And I, to give you a little bit more context, I look at 938.29 actually, where if you just go 2 subsections down, in 938.29(1)(a), the verb set is used again, and it says it is treated differently than the verb to affix, right? A defendant who is convicted of a crime, a criminal act, or a violation of probation, and who has received the assistance of the public defender's office or a private conflict attorney, blah, blah, blah. Attorney's fees and costs shall be set in all cases at no less than $50 per case when a misdemeanor or criminal traffic offense is charged, and no less than $100. The court may set a higher amount So it just 2 subsections later, the verb set is being used as a synonym to fix or to establish and not necessarily to impose.
I see.
How do you get around that? How do you get around the fact that just like a turn of the page later, the verb is being used in a different way than what you're suggesting?
Because in subsection 8, it goes on to say costs recovered on behalf of the state attorney under this section may be deposited into the state attorney's revenue trust.
Yeah, that just tells me where it goes.
Okay.
I guess my point is the state is arguing that a certain usage of the verb set means that it is charged. And
right.
I'm saying that's not, I don't think that does what you think it does. It just says what the cost shall be. It affixes the amount of the cost. It doesn't say that it will be imposed by necessity.
It doesn't, but it does, I would respond that in subparagraph 1, it does say in all criminal cases, convicted persons are liable for payment of costs of prosecution.
Well, that's different. That's different. Now, whether or not, now we're back to subsection 1, but the argument you led with was that our reading of subsection 1 needs to be informed by subsection 8.
Exactly.
And I'm saying that doesn't really do the work you think you think it does. It just tells you how much. It doesn't answer whether or not it needs to be requested.
Okay, but if it needed to be requested, the legislature would have said in subsection 8, it would have added language that the cost for the state attorney must be set in all cases if requested. And by choosing not to do so, the legislature indicated its intention that a request was not required. In order for the cost to be imposed. Okay. The section provides for the imposition of costs of prosecution in criminal cases, and under this umbrella of costs of prosecution, it provides for in relevant part for imposition of 2 distinct subsets of costs, the cost for the state attorney and the investigation costs. The 2 costs are treated very differently in the statute. The language of subsection 1 expressly conditions the imposition of the costs on a request by an agency for payment. Subsection 7 and 8 address the subsets of costs separately, reflecting that the investigative costs and the state attorney's costs are distinct and that the cost of prosecution is an umbrella term.
And so that larger category of costs of prosecution, is that entirely made up of state attorney costs plus investigative costs?
It is.
There's nothing else that goes into that basket?
There's nothing else. There's nothing else. It's the cost of prosecution and the investigative cost, and they're distinct subsets that are...
Well, no, the cost of prosecution is a subset. I mean, I'm sorry, the investigative costs are a subset of the cost of prosecution.
I'm sorry, I thought that's what I said. Yes, that's correct.
But then the only other thing that's included within cost of prosecution, you're saying, is the state attorney's costs.
Right.
Okay.
And what's included in this, the state attorney's costs can include a variety of things, but they're costs that the state attorney expends in prosecuting the case. So, yes, that's, in my view, it includes just the state attorney costs and the investigative costs. The separation of the subsections reflects a legislative choice to distinguish between the 2 subsets of costs. And they had no reason to address the subsets separately unless they intended to for the provisions to be construed separately. The text of subsection 8 reflects the legislative determination that the minimum value of the services provided by a state attorney is $50 or $100, depending on the cost, or depending on the nature of the offense charged. And the minimum costs are mandatory, although the state can ask for a higher cost if it presents proof and has a hearing. In contrast, a minimum cannot be set for investigative costs because investigative costs can vary greatly. And so I would close simply by, unless there are any further questions, simply by noting that although someone might find it a little bit unclear about which antecedent, if requested, applies to, the language in subsection 8 makes it clear what the legislature meant, which is they would have said in all cases if what it really meant. They wouldn't have said in all cases if what it really meant was in all cases if requested. If there are no further questions, I would ask the court approve the decision of the First District of Appeal on the Parks.
Thank you.
Since I'm not getting too far on the clear and unambiguous language, let me mention that the intent the legislature had in amending this chapter, it was to relieve the state of the burden of proving any costs. And it was to take away the ability of the trial court to take into consideration the defendant's ability to pay. So what the state gets out of this amendment is it does not have to prove up anything if it wants the minimum amounts. What that also does is precludes the defendant from having a hearing or fighting those minimum amounts in any way. That's why it says the costs are set. And I think that your point about the public defender fees, they use the word set. They also say shall be liable, which isn't included in subsection 8 here.
I don't think anyone here would turn to intent rather than the clear import of the text. I think the trouble is that just establishing the liability and just setting the amount doesn't answer the question of whether it must be requested. It seems the much more difficult textual challenge for you is the following statement: the court shall include these costs in every judgment rendered against the convicted person. That's the textual force that I find very hard for you to get around, because just because I'm liable for something doesn't mean I must pay it right now. I can hold those two concepts. What resolves the case, in my mind, is that statement that the court shall include it. It doesn't, we're not talking about what triggers that. That is clear and unambiguous. And I wonder how you get around that. I wonder how you get around the fact that whatever the liability of the convicted person, the statute operates on the court, and it says you must include this. And it doesn't talk about a request.
But, Your Honor, would you agree that that cost to the Tallahassee Police Department cannot be paid if they don't request it?
Well, I love that we're having this back and forth, but I think my question remains unanswered, which is how do you get around the fact that the operation of the statute is on the court?
Because, Your Honor, that statement is exactly why I think that my argument prevails, is because the legislature is saying must be, I forget the exact language, but we know that's not true. We know that's not true because
What do we know is not true? I'm not following.
We know that those costs cannot be imposed without a request. The investigative costs cannot be imposed without a request. We know that. No one has argued that the fire department can get these costs even if they don't ask for them.
That's why the statute says if requested by such agencies.
That's correct, Your Honor.
That's exactly the point.
Exactly. But then the next line says shall be imposed in all cases where requested. It has
doesn't
to
say
say
that.
that. Your Honor,
It doesn't say that. It says the court shall include these costs in every judgment rendered against the convicted person, period.
but it cannot impose those without request. This court said that in Richards. It said those two statements have to be analyzed together. If we only look at that last statement, we would not be aware that in an arson investigation you have to prove what costs you had. But that's what the legislature says here, and that's what this court interpreted it to mean in Richards. Subsection 8 only tells us the minimum amounts that they're going to be cost. And the legislature did that because it can set a floor for the cost of prosecution. And the statute clearly says cost of prosecution, including investigative cost. It doesn't say cost of prosecution, but excluding state attorney costs, which is one subset of the cost of prosecution. It clearly applies to all cost of prosecution.
Okay, you can have 30 seconds to wrap up.
Your Honor, we would just ask that you quash the opinion from the first DCA in Parks and that you adopt the holding in the second DCA. Thank you.
Thank you very much. Okay, our next case is Steak and Shake versus Ramos, number 2024-0099.
May it please the court, counsel. I'd like to reserve 5 minutes. My name is Bob McCormick. I'm representing Steak and Shake. I'd like to reserve 5 minutes for rebuttal, please. Primary purpose of the administrative requirements in any statute, or at least in this statute, as has been stated in different cases, is one, to notify the employer of the discriminatory practice, and two, to provide the commission with the first opportunity to perform its role in obtaining voluntary compliance and conciliating the matter. Here, both my client, Steak and Shake, and the Florida Commission were denied the proper notice and that opportunity because Mr. Ramos solely elected to seek relief under the Federal Americans with Disabilities Act.
Can you elaborate on why? I mean, substantively, the law is the same, right? In terms of the conduct and what would give rise to liability. I know that there may be different, limitations periods or different, administrative requirements. But in terms of you knowing sort of what the factual allegations are and liability, I mean, is there? My sense is there's no difference between the ADA and what the Florida law.
There are subtleties, Your Honor, but I think you've characterized it correctly in that substantively they're largely the same. There are a lot of differences when it comes to procedure, and there are, I would say, significant differences where it comes to relief also. And that's important here because, as you know, the statute not only requires the charging party to identify the basis for his claim here, but also the relief sought. And the relief sought is a very large part of why solely identifying the ADA as the basis for your claim in this particular instance, when you read through the charge of discrimination, there's nothing else. There's no other way to ascertain the relief.
Could I just press on that for a minute? The charge of discrimination is a 2-page form, or I'm sorry, is operatively 2-page. It includes some instructions after that. And we are reverse engineering a lot of legal decision-making from the fact that it ticks a box that just says charge presented to EEOC. It doesn't talk about the substantive choice of law. It just says to whom, whether to the FEPA or EEOC it is presented, and there's a work share agreement between the two. And then when it comes to the discrimination statement, it is just essentially one sentence long. I believe that I have been discriminated against on the basis of my disability and or perceived disability and by retaliation for my request for reasonable accommodation in violation of the Americans with Disabilities Act of 1991 as amended. It sounds to me like all this is a statement of a request for accommodation. I think we're reading into this a whole lot more than what's there. It seems to me like this is a general statement at that point by a pro se claimant saying, I believe that I was retaliated against because I wanted an accommodation and I didn't get it. That would seem to sound to me in both federal and state law, and I don't hear any limiting language where he says, I mean only for this to be the case under the ADA.
But what relief is he seeking, Your Honor? I don't know that he's only seeking an accommodation. At the time that he filed this charge, his employment hadn't yet even been terminated. So your presumption could be correct. But to me, the argument you just made to me seems to be a little different than what you're arguing is the legal error on appeal, in that he failed to explicitly reference Florida law. And so if I understand your brief correctly, from a textual standpoint, you're tying that term into relief. In other words, the legal requirement that you see that the statute provides to name both federal and state law, if federal law is named, you tie to the word relief. Correct? I think there's nothing else to tie to the relief, Your Honor. I don't know what else you could, because he didn't ask for any relief other than identifying one statute.
Well, the way that you just used relief there in the argument proceeding was the type of relief. So accommodation, reinstatement, back pay, damages. How would we discern from the statute, just on the plain language of the statute, that term relief also requires a statement of the law violated?
I don't think it gets us there, Your Honor. Honestly, I think that I'm being very generous with my interpretation, in that the relief sought isn't really in there. I mean, you have to really,
but that's your whole argument in the brief is based on the idea, as Justice Sasso was saying, is that the requirement to name, if he had said, I was discriminated against in violation of the Florida Civil Rights Act, that wouldn't tell you what relief he's seeking.
No, but it would give us an indication of what we were defending. And if you look at...
But you know what you were... I mean, that's the thing. It just doesn't... So, go ahead.
But on this, you can see that there was a dual filing. It's a filing with the EEOC and with the Human Relations Commission.
So the charge says, yes. The record does not...
Well, I mean, you can see that,
yeah,
though. I mean, you're not contesting... You're not saying, well, this is not prop... You're not saying that this was not properly filed with Florida's FEPA, the Fair Employment Practices, the Florida Human Relations Commission, right?
I don't think it was, Judge.
But you haven't argued that.
Well, I know, but if you
and as a matter of fact, you have said the opposite.
It's in the record.
I mean, I'm not trying to be hard on you, but I'm just like...
Let me clarify. If you look at...
But don't clarify in a way that's inconsistent with what you've argued in your brief.
Okay, so even if this was duly filed properly, which he did ask that it be duly filed. If that's what you're getting at, I stop there.
Well, I guess I find it kind of confusing. I think this issue's off the table, because I think you have conceded that it was duly filed. But when I look at it, I mean, and maybe it's because I don't understand how this works, But it seems like to me that that duly filed means the charge is presented to both agencies.
Right.
And that would mean both those, the FEPA box would also be checked, and there are two opportunities to do that. And neither's checked. And then it's also got the blank line for the state or local agency, if any, and the EEOC, and that blank line is not filled in. Now, maybe that's just the way it rolls, and they never do that. Your concession seems to be based on this boilerplate language above his digital signature that says, I want this charge filed with both the EEOC and this state or local agency, if any, correct?
Correct, Your Honor. The issue here, however, is proper notice. Proper notice. And proper notice was not provided. If you look at the language in Bellany, which is
but it seems like to me, once you know it's filed, to some extent, if it's filed with, once you concede that it's been filed with the Human Relations Commission, you kind of got notice that he's wanting to go down the Florida law track. You've got notice of that.
But it's not just notice to us, it's also notice to the Florida Commission that's required. And so bear with me for a minute. Bellany is why we're here. Bellany states, it is axiomatic that an employer cannot be placed on notice that a claimant is claiming a violation of the FCRA when his charge only asserts a violation of federal law. That's us. That's the employer. Sunbeam Television is the one that I quoted first, saying notify the employer of the discriminatory practices and provide the commission with the first opportunity to investigate and conciliate and seek voluntary compliance. So that part of it, I'm not conceding, because I don't think that was done by the record that we have here. And if you look at the record, the notice that was provided under the work-share agreement, which of course we all know requires that the charge be transmitted within 10 days. We know that wasn't done. It was 150 days that this form indicates, and that's record 171, the form indicates that the charge was transmitted. There's nothing on that that's suggested. In fact, there's indicia to the contrary, because we have Michelle Wilson, the director at the time, name typed in by the EEOC that prepared the form. We also have a place for her signature saying she received it, which isn't signed, and we also have brief. I'm sorry?
Is any of this in
no,
your
that's
brief?
not in my brief.
Why are we talking about it?
Okay.
I'm truly confused as to how this is relevant to the issue that's been presented on appeal.
Well, it's relevant because it doesn't show that there's been actual opportunity.
But that's, sorry, go ahead. If we're focused on the legal issue has been presented as a conflict between the districts.
Right.
Which is whether or not, in order to meet the statutory condition precedent, one must allege a violation of both Florida and federal law if the reference is to federal law. It has nothing to do with whether or not something was actually filed in the right location. Correct. So how does that, whether or not it was filed, inform the statutory interpretation of what the statute requires?
I think because the important point is that you have to, in order for you to do what you're charged with doing, you have to actually have the notice. And so when you choose...
Can I ask you a question on that in terms of operation, of how this operates? Is there any reason, in terms of just the act as a whole and the way it's structured, including the administrative rule, to dual file if you are not seeking relief in the state courts or under state law?
Yes, because you can have either agency investigate any claim. And in this case, the agency that received the charge was investigating an ADA claim. It's the federal agency that received it. The state agency could receive it and investigate only an ADA claim, or they could investigate a state claim. The statute also says that a fair employment practices agency, a local agency, could receive the charge and do the investigation and seek conciliation.
So in terms of the rule, though, that you want us to, in terms of what our holding would be, because you emphasize a lot that it specifically mentions the federal ADA. But if the narrative here had just said, I was discriminated against because I'm disabled and I want back pay, front pay, whatever, an accommodation, then in that case, the mere fact that it was dual filed would be enough to put you on notice?
If you read Bellany, that's exactly what they came up with, Your Honor.
So, I mean, wouldn't that be, so ironically, an intelligent filer, and this is part of the challenge here, is this is kind of set up to be a trap for the unwary. I mean, because the requirements that you're kind of arguing for, the form is not really designed to capture that. So basically, I'm better off not saying whatever law might apply, which I don't know how that helps you with notice. I'm just describing facts, and then that puts you on notice, I guess, according to your theory, of any law that might possibly apply.
Well, that's where you have to get into the procedural aspects of this, because as we know, the law requires the Florida Commission to act within 180 days. And at best, they didn't get the charge until 150 days had passed, because it relates to the date of filing. It doesn't relate to the date that the Florida Commission actually receives the charge. So I think that had the Florida Commission received the charge, there's a possibility they take and that's what the form that I was getting at that wasn't signed actually says, is the Florida Commission has the opportunity on that form, if they sign it and they get it, to say, yes, we want to investigate this charge, or no, we're not going to investigate the charge, and they send it back to the EEOC, and that's where the work share actually is sharing, whereas here there was not any kind of sharing that it appears to have occurred.
I feel like I'm just not following this part of your argument, so I just want to make sure I'm clear, because I think I'm misunderstanding. Are you saying that the fact that these two government agencies didn't operate perfectly together should be held against Mr. Ramos?
No, what I don't think it's, in part it is, it relates to him, but what I'm saying is it shouldn't allow him to get into court under only Florida law in a Florida court, because that ship had sailed for him already. He didn't do what he needed to do at the time that he should have done it in order to perfect the claim, and that goes to the subject matter jurisdiction of the trial court.
But specifically what he failed to do, so if he had not mentioned the ADA, he would have been okay.
He probably would have. I see that I need to reserve some of the
Right.
time for rebuttal, and this actually gets to some of that anyway. Thank you.
Okay. Well, I mean, but no,
Answer his
but I mean,
question.
yeah, I mean, if
So
we can give you
what
another
was your
minute or
question,
two.
Judge?
You're going to be limited to whatever, you're going to be able to respond to what she said. You can't save more stuff for
Right.
a rebuttal. So.
What was the question again? I'm sorry.
No, my question, you're saying he failed to do what he needed to do, and it sounds like it was more an error of commission by mentioning the ADA, potentially, is another way of looking at it. Because the way I understand your argument, if he hadn't listed the ADA, then he would have been fine.
Well, don't forget, he's not just doing this on his own. I'm sure he didn't come up with that. He's getting assistance from someone internal.
I mean, that doesn't matter. I mean, as far as because we have to think about what it would mean for the future, because it sounds like you're saying that if he lists no statute and it's dual filed, then that's okay.
That's how I read Bellany, and I think they're right.
Thanks.
All right, may it please the court? My name is Ashley Richardson, and I'm representing Mr. Ramos.
Could you speak up a little bit? I'm
Yes,
having trouble.
which is, I don't think anybody's ever said that to me before. Yes, I will do my
You've never talked
best.
to a judge as deaf as I am.
I will use my outside voice as I tell my child. My name is Ashley Richardson, and I'm representing Mr. Ramos in this one. I actually want to address sort of my own arguments in reverse. My colleague was talking about sort of the greater implications of what a ruling from the Supreme Court on the split between Bellany and Ramos could actually look like. And I think that's particularly important here. Mr. Ramos was a pro se individual when he contacted the EEOC, who helped him prepare this charge. As has been mentioned a number of times, that's a form document. So in order to comply with this very narrow and sort of odd ruling that Bellany has put out there, and essentially a layperson, this aggrieved employee, is going to have to know that they need to alter the form document to include these sort of I'm going to call them magic words or a password, in the particular section in order to be considered filing their or preserving their state law claims.
To that point, I note that the form nowhere says, what do you want? It says the particulars are.
Correct.
And then the discrimination statement, and so there's personal harm and discrimination statement, and it breaks those two things down. My question for you is, obviously we'd be in a different place if not just, there was no choice of law to the Chief's question, but also if he had affirmatively said, I seek reasonable accommodation.
Correct.
Right? Is your argument that even though he didn't phrase it that way, the statement that I believe that I've been discriminated on the basis of my disability and by retaliation for my request for reasonable accommodation means that his request, his prayer for relief was just reasonable accommodation? Or is there some other prayer for relief that you see here that I don't?
I see it as as you've just stated, that he is indicating that he was denied a reasonable accommodation, had not yet been terminated when the first charge was filed, and thus would be seeking to redress that by having his accommodation either granted or.
And then to that point, when he is terminated, he doesn't amend this to seek wrongful termination or back pay or front pay or anything else, right?
Right, and I mean that's not an issue presently in this one, but no, I do believe that that's correct.
So your claim rises and falls on whether this statement is a sufficient prayer for relief, that he wanted reasonable accommodation.
That, and I think the larger argument here is, does the charge as a whole actually indicate to both commissions and Steak and Shake in this instance that he intended to potentially pursue state law remedies at a later time?
Yeah, because your claim, they're not arguing about this rule. I think that if we were just looking in the abstract, did he comply with the statute by, the short statement of the facts and the claim for relief? But that's not, they're not defending it on that basis. The issue is whether the failure to, name the combination of the failure to name and or the affirmative naming of the federal, if that didn't put them on notice.
Right. It's actually,
there could be another flaw with this, but that's not what this
right. The exclusive flaw that we're addressing on this one, the distinction between the Bellany and the Ramos opinions here, is just that inclusion of and the FCRA at the end of the particular section. And I think that argument has to fail for a number of reasons. The first being that Chapter 760 itself says that it should be interpreted and construed liberally to allow an aggrieved employee access to the remedies that the Act itself provides. And by limiting this...
But that's an argument about how 760 should be construed, not an argument about how this form should be construed.
Correct, but the form is sort of part and parcel to whether or not he's able to preserve or to continue his claim in court.
The form is an EEOC form, right?
Yes.
So it's not a Florida form.
Correct.
Okay, so I hear the desire when you say that the statute should be construed liberally. Okay, great, but that doesn't tell me that this form needs to be construed liberally.
I understand the point there, and I think that if we look to 760...
What provision of 760 do you want me to read liberally?
Well, it's less about reading... I think that 760 in our case needs to be just read as it is. The interpretation that Bellany takes would severely restrict that, and that the Bellany opinion is what I'm arguing has not been sort of liberally construed or even follows the statutory text.
As he's saying, the liberally thing only matters once you've identified the part of the statute that you're trying to construe. And so are you saying there's no, what specific part of the statute does it turn on?
Sorry, I didn't mean to interrupt you. 760.11 sub 1, the actual instructions for what it takes to file a charge sufficient to preserve your state law claims. And if we actually look to that particular provision, it's very specific. You have 365 days. Your charge needs to include the name of your employer or the person who's wronged you in a short and plain statement of those facts and the relief sought. Right? In the middle of that section is the phrase, in lieu of filing the complaint with the commission, which is defined as the FCHR, a complaint under this section, the FCRA, may be filed with the Federal Equal Employment Opportunity Commission. So they provide dual filing right there as a method of satisfying these administrative prerequisites, essentially getting your claim before one of the agencies. Mr. Ramos did all of those things here. There's we discussed all of the various checkboxes and whatnot on the EEOC form, but directly above his signature is the line, I want my charge to be dual filed with the state agency.
Do you think that does anything towards the statement of relief, or do you see that as separate?
The statement of relief issue, I think that what he's included in his particular section, I believe you mentioned this actually when my colleague was up, is that, for example, if I file a charge and say that I've been discriminated against on my gender because somebody else got a job that I think I was entitled to, I could say, and I want that job. And that would be asking for relief. In the petitioner's reply brief, they insist that asking for relief means that we need to identify the statutory scheme at issue, and that is nowhere in Chapter 760 that there's any requirement. He's got to put the name of his employer and what happened, when it happened, so that we can determine whether or not the complaint was timely filed.
And the relief sought.
And what he wants, right?
Yes.
Can you help us understand this form? So this boilerplate that's above the signature, did he have to do anything to make that appear, or is that just there?
I'm pretty sure everything on that form except the particular section and the personal details is part of the form.
Okay. So it says, I want this charge filed with both the EEOC and the state or local agency, if any. And then if you go to the next page of the form, there's this line that has beneath the line it says state or local agency, if any, and then and EEOC, but there's nothing written in there.
I agree with that.
So, I mean, and maybe he waived this by maybe because it got filed, maybe it shouldn't have been sent over to the Florida thing, who knows, but in terms of indicating, if you actually had to do something affirmatively to have it be dual filed, I mean, is it a fair reading of this form to say that he didn't actually do it, since he didn't check the FEPA box, he didn't fill in the agency thing here, and then this language, I could see if there was a box here or if he had to do something to make that language appear, but that was just on the form, it seems like.
Right, and I think that, I understand the argument here, but I think that there's a long line of cases, starting with Gregory out of the 11th Circuit, that has trickled down through various courts. It's sort of the check the box line of cases, is what we've referred to it as, and that's where we need to look at the charge as a whole. So there's a lot of instances where, for example, someone will forget to check, let's say, the gender box, but their particular section exclusively or extensively talks about gender discrimination, providing examples, the names of comparators, other information. In those cases, notice has been found sufficient that the gender discrimination claim is preserved, even though the box was not checked.
So you think the whole dual filing thing is irrelevant then, too?
Not necessarily irrelevant. I just think that
but
it was
he didn't
done.
do it. But if he doesn't do anything, it sounds like the fact that it was sent over to the Florida agency was almost kind of by accident, in the sense that he didn't do what you would need to do if you were filling out the form to make it dual filed.
He didn't check the box, but he also didn't prepare the charge. He worked with the EEOC,
Well,
and then, Okay. I'm not.
You could have. If we were going to get into that, then it wouldn't matter what he even said about what his claim was.
Correct. No, I understand that.
But look, just to make sure I'm understanding this, and again, I'm not sure it matters for this case because I think this point's been conceded, if I understand it correctly. But would that FEPA box ordinarily be checked?
I've seen it checked, yes.
Okay.
And as a plaintiff's attorney, I would prefer that it be checked, obviously. But I think
and would that line on the second page, the blank line above a state or local agency, if any, be filled in also?
I have actually seen it both ways. I feel like
so sometimes they might check the box but not fill in the line.
Correct.
And I assume that sometimes they might fill in the line and not check the box.
Most unfortunately, I'm a rule follower and it drives me insane. However, there are significant...
But that's the incompetence of the... Well, maybe it's chargeable to the complainant, but maybe it's explainable by the incompetence of the folks at the EEOC.
Right, and this is where the liberal construction comes into play. We can't penalize, particularly a pro se employee, for relying upon the services of one of these agencies, and this is the charge that's generated. They read the particulars, their name is spelled correctly, the person who wronged them is included, and they sign the form, and they assume that they've done everything correctly. And that, to the point that was sort of brought up in the previous argument, the employee cannot be charged with the failures of the agency. And there's actually the Roeder v. DEP case out of the 1st District, which was a date stamp case, but same general concept that I've done my job according to the statute. I've filled out the form. I've included all the information that I'm supposed to. I have turned that over to the agency. If the agency then fails to do something that it is supposed to do, that is not chargeable back to the employee. The fact that the EEOC waited as long as it did to send the charge to the FCHR, that's not Mr. Ramos's fault. But the fact that they did send the charge to the FCHR strongly suggests that he did, in fact, dual file the charge. And I don't think that there's really any dispute that that happened. It's whether that happening is sufficient to preserve his state law claims. It's an incredibly narrow argument. And I think the fact that Bellany points out, if you said everything or you said nothing, you get to go to court. But if you say a little bit, you don't get to go to court. And that can't stand. That puts a whole class of persons, aggrieved employees, at risk of losing their rights under Florida law based on a bizarre technicality that's not actually part of the statute.
We're talking about timing, and I'm wondering whether this, just to shift the subject a little bit, I'm not sure that Mr. Ramos is the right person to be making this argument. But so if I understand the facts right, the EEOC mails him a notice of his right to sue, and then he waits 16 months to sue.
Yes.
Do you have a time bar issue? Isn't the law that he's got a year?
We don't. He has 4 years under Joshua. I actually just argued this before the first DCA yesterday, that under the Joshua line of cases where there's no notice from the FCHR within 180 days, the 4-year statute of limitations under 9511(3)(f
That's really interesting, though, because that does seem to suggest that it matters which rubric he chooses, which legal rubric he chooses, because, I mean, you sort of live by the sword and die by the sword here. In order for him not to be time barred, you need for him to be filing this with the EEOC and not the FCRA.
The first DCA yesterday actually made a similar point. I don't think that argument follows through, though, because they contemplate that the other agency may be the one to act or investigate on their behalf. They have different deadlines associated with it. For example, if you get a notice of right to sue from the EEOC, you only have 90 days to bring your federal claims. If you receive notice from the FCHR within 180 days, which was always a possibility, the FCHR has every right and ability to investigate any charge that comes before it, whether it's provided by the EEOC or not. They just chose not to do that. We have no idea why in this case. And they also have the ability to issue any kind of statement, even if it just says, we're not doing anything with your case, proceed to court. If they do that within 180 days, Mr. Ramos is limited to a 1-year statute of limitations. If they don't, it's the 4-year statute of limitations. And that's this court's opinion in Joshua in 2000 that still hasn't, it's still valid law. So to that point, there could be a timing issue. It's not at issue here, but it's also not an issue, period.
So if you put yourself in the position of the respondent, what, in terms of how this whole thing works, what are they on notice of? I mean, when someone does specifically, identify the federal law, they're silent on Florida law, they're not doing anything explicitly to even do what you need to do to indicate that you want the Florida agency to look at it. I mean, what's going on from a notice perspective?
I think notice
for Florida law.
I think notice was provided. We have the statement above his signature that says that he wants it dual filed. I agree that it would.
But that's on every single form. Right?
I don't actually know the answer to that question. I think that it is. I think that the majority of that language is standard, but it's still included, and his signature is directly below it. So
basically, then I'm not saying that this is bad for you necessarily. I'm just trying to see if there's a way to make sense of this. But basically, then, even when they only identify federal law, essentially the notice, you kind of have to focus on the factual allegations and look at the substance of Florida law and just kind of figure it out for yourself. But basically, from a notice perspective, the fact that the person who's complaining only identifies federal law, that's basic from your perspective, that it's irrelevant, and that they're sort of, what kind of notice of the Florida claim, or what's the source of the notice that they might be on the hook for a Florida law violation?
That, in any circumstance, is going to be the request to dual file the charge. And that's what the statute itself says in subsection 1, is that in lieu of filing directly with the FCHR, you can file with the EEOC and still preserve those state law claims. So while there could be additional language, or perhaps the EEOC form could use a little tweaking to be a little bit more specific, in this circumstance with the forms that we are looking at, Mr. Ramos requested that it be dual filed. There's really no dispute that it was, and that should be sufficient notice to the employer. It was sufficient notice to the EEOC, albeit late, to send the charge to the FCHR. So everyone was aware that this was going to, that this was a possibility. Now, in terms of the facts and the other identification or the other information provided, that's all, the claims are essentially the same in terms of what factual support is required under federal and state law. So again, providing the particular section lets Steak and Shake or any employer know, what are we talking about here? Who did the bad act? What do I need to investigate? Did something really occur? It gives them that opportunity to respond to the charge should the agency fully investigate it and request some kind of response from the employer. So that notice is provided. No one was without it at this point. We just have this one outlier case in Bellany that provides this very specific and very narrow exception that would prohibit probably a number of employees from proceeding with Florida claims if this was to be the law going forward, which again, sort of back to the liberal interpretation, that runs contrary to that. If we're allowing, if the statute allows for dual filing, the FCRA has contemplated that, okay, we're going to just let them file with either because it's just less bureaucracy, makes the process a little easier on the employee. If we include this very specific password language at the end, what's the point of dual filing? If dual filing preserves your charge.
Well, but I mean, you could also say, what's the point of notice if you can just kind of allege only one law and then claim that you've given notice of the other stuff. I mean, you have strong arguments on the substance, but
right.
It's just, I guess I'm not sure how much sense this all makes.
Well,
I think
I think that, and I agree with that sentiment. I think that this all goes, for our purposes, we have to look at the charge as a whole, and that's the Gregory line of cases about checking the box.
Can I ask you about the administrative code and how that plays in? So the Florida Administrative Code, the rule seems, the statute leaves a lot of room. And then the administrative code comes in and says, complaint sufficient if it's in writing, signed by the complainant and verified, and sufficiently precise to identify the parties and describe generally the action or practice complained of. I mean, is that consistent with your interpretation that if he's complaining of an action that violates the ADA, that under Florida law, that violation would be similar?
Absolutely. I think that the section that you just read from the code is perfectly in line with the requirements of 760.11 sub 1 that just says, essentially, we need the basic information about who you are, who they are, and what happened in order to determine if we can actually investigate this. There's a line of argument in the petitioner's brief about the phrase under this section and its applicability to sort of the argument that we have here. And that's because there are other civil rights statutes. There's Fair Housing Acts, there's public places, things of that nature. So to bring that claim under this section, we need to provide the information that you just read: name, rank, serial number, employer, all of those things, to make sure that the FCHR knows that it's investigating a workplace discrimination claim, which is what the FCRA prohibits. If we started talking about fair housing, for example, in that charge, the FCHR would say, we don't have jurisdiction to hear this particular claim the way that you've brought it, try again. So that's really what we're sort of bringing that back to. So if there are no additional questions, we would just ask that this court affirm the second DCA's opinion in Ramos and quash the one in Bellany. And thank you for your time.
Thank you.
I think this is starting to bring it all together. The notice issue is why I'm focused on this, because if you look at the position statement, Steak and Shake on May 10th filed their position statement. There's nothing other than federal law cited in that position statement. They're defending a federal claim only because it was pointed out that there's a federal claim only. And again, even though Ms. Richardson claims that
but
Bellany,
it doesn't say only. I mean that's the inference, because there's a reference to the ADA, which has provisions that are essentially identical in material respects to the Florida law, but that doesn't say only. But anyway, I understand that's the kind of the basis for your argument, but That's kind of the question. Does the fact that that's reference mean that reference to the ADA is there mean that he's only talking about the ADA when he's asking, when it's conceded that he's asking for this also to go to the state agency?
Well, I would disagree with the interpretation that under this section means as an employment discrimination claim. It means under this section, which is under the Florida Civil Rights Act, and that particular section of the Florida Civil Rights Act. And every case that's interpreted it, except for this one, has interpreted it exactly that way, that you have to give meaning to the words of the statute. And those are the meaning, that is the meaning of those words. And this is, Bellany's not the outlier. This case is the outlier. I want to address the access to remedies argument that Ms. Richardson made, because there's nothing in the record that prescribed any access to any remedy that Mr. Ramos had. And he had several opportunities. And if you look at the timeline, he wasn't fired, but he filed this claim in November 14th, 2017 was his charge, record 151. On May 10th, my client submitted its position statement only addressing the federal law. He received a right to sue on September 4th, 2018, giving him 90 days to file an action in federal court, very specifically laid out his rights. And it's interesting because on November 4th of 2018, Mr. Ramos still had time, if he chose to pursue his state remedy. He could have actually filed a claim with the Florida Commission, could have followed up. There's plenty of communications within the record between the parties. The only ones with my party saying they would agree to mediate in November when they were asked, and the May 10th position statement where they're only defending a federal claim. So waiting that much time to file only under state law when he hasn't exhausted his administrative remedies, it deprives the court of subject matter jurisdiction, and that's really the basis here. My client shouldn't be required to have to defend a claim over 4 years later when the claim had expired, really. And so that's that's the point. So given that, I would ask that you reverse the second DCA and uphold the decision in Bellany. Thank you.
Thank you, sir. We're going to take a 10-minute recess.
All rise.
I don't need it. It's beyond my bandwidth to do that here. I'm trying to learn to do it all electronically. It's pretty slick. It's not as good as paper, in my opinion, but you can't do shit about it.
Interesting.
I barely use the opposition when I use pen stuff. Most people here for a capital argument with several bankers' boxes. What's the point? I don't know. Where does the record show?
All rise. The Florida Supreme Court is now in session. Please be seated.
Okay, our next case is Wolf versus State of Florida, number 2023-1077.
Good morning. May it please the court. My name is Andrew Stanton. I'm an assistant public defender, and I'm here to speak for Stephen Wolf. I'd like, if I may, to begin with the issue of venue. The state's trial theory was speculative, and the state's theory here on appeal is contrary to the facts. And if the court will indulge me, I want to go through the timeline a little bit because I don't think I did a particularly good job in the briefs of explaining that. The van, Mr. Wolf's van, left Florida City at 11:29. It arrived at Vaca Cut at 1:19. That's an hour and 50 minutes later. Detective Alvarez said the trip would take 1.5 hours to 2 hours. At 2 o'clock, the first officer on the scene, Officer Aguano, touches the body and finds it cold to the touch and rigor is set in. And crucially, this testimony, the body was moved between 5 and 6 o'clock. And here's what Dr. Steckbauer, the medical
This is in the
examiner,
afternoon. I mean,
yes, I'm sorry.
If you give AMs and PMs, that would probably be clearer.
I apologize. I started with AMs 11:29 a.m. And now I've gotten us to 5 o'clock p.m. When Aguano touched the body and found it cold, that was at 2 p.m. Not that long after Ms. Osborne's body was left there. So the body is moved at between 5 o'clock and 6 o'clock. And The observation is, or the testimony is this is unquestioned by the state, talking about livor mortis had set by that point. The state says this usually takes anywhere from 4 to 6 hours before it sets, correct? Answer, actually it's longer. Generally speaking, liver is fixed by about 12-ish hours. But you were told when they rolled her, it was already fixing. Yes, I was. So actually more than 6 hours then, as you testified, right? That would put us more towards 12 hours or greater time frame. So that would put us, as the state argued below, more towards 5 a.m. or 6 a.m. Now the state here on appeal tells us, well, we can establish venue how? Well, Mr. Wolf said that Ms. Osborne was killed on the drive down from Florida City, even though that's contrary to the medical evidence. But no one here or there believes that statement. The statement was that she was killed by someone else in the back of his van as he made this drive about nearly as fast as you could between the 2 points. The state says, well, he said it. It must have been the fact that Mr. Wolf committed these crimes in the tiny space of time that was left between Florida City and yes.
Forgive me. Let's say we agree with everything you've just said. Isn't the state's burden merely to present some competent, substantial evidence from which the jury could infer that Monroe County was the place where the crime was committed?
It's been phrased a number of ways. That's close enough.
Yeah, I guess
it's been called a preponderance of the evidence.
Well, that's a different standard. I guess my point is if we have a competent, substantial evidence test on venue, then okay, you can direct us to all sorts of evidence in the record that breaks in your favor, but that's not the question before us. The question is there competent, substantial evidence from which the jury could make that inference?
Right.
You'd have to establish that there is no competent, substantial evidence. So let me hear you on that.
Okay. On that test, as I say, there are several ways that it's been expressed. There is no evidence whatsoever that this occurred in Monroe County. We know from the medical evidence it could not have occurred between the time that the van left Florida City and the time it arrived at Vaca Cut. Contrary to the medical evidence, contrary to everything we know. And the statement doesn't get them anywhere because it is contrary to the evidence we believe rather than the statement that everybody rejects and is inconsistent with other parts of the evidence. And the state, in further support of that, says, well, you know, the body was found in Monroe, the bloody clothes was found in Monroe, but that doesn't add anything to the question of where the body was at the time Ms. Osborne was killed. And we know that the fact that bloody clothes was disposed after the body was dumped at Vaca Cut is the one thing that's consistent with Mr. Wolf's statement, which at the point that the body was out of there, he needed to clean out the van and clean out bloody clothing and left it as confirmed by the state's evidence in a number of places after he was in Monroe County.
So now, your theory is that she went on a ride with him to Dade County?
That was the state's theory at trial.
Okay, and that's your theory now. Okay, so
she got to Dade County one way or another. I'm happy to argue it on the state's theory below.
And then he murdered her in Dade County and then brought the body back and dumped her body in the neighborhood where she apparently lived.
We don't know how close it was to where she lived, but you know, to the extent Monroe
well, in their
was
testimony, that she
fisherman
was kind of a homeless person that haunted that area.
Yeah, the fisherman said that he had seen her at the gas station. You know, sometimes in Monroe County transcripts, everybody knows where everything is, so you're left to speculate a little bit. But at the gas station, who knows how close that was, but again, it's the Keys. It wasn't that far away. And he had seen her. She was a homeless person. He had seen around that gas station. I believe he said drinking. So we have no definite location, but sure around there. I don't think there's any significance to attach to that. Maybe the theory is that he was bringing her back to where he found her. But we know one thing is that the body was in Dade County at some point before the van left. Alive or dead, Ms. Osborne was in that van. Nobody would dispute that. There is no account that disputes that. So we're left, if we accept the medical testimony and reject the idea that she was killed on the trip down in a possible time frame, both on medical testimony and the travel, and was somehow cold a short time later. If we reject that theory, we are left with the trial theory, the theory that the state actually went under before the jury, and that was that Mr. Wolf picked her up or otherwise encountered her in Monroe County, and that he necessarily murdered her in Monroe County before going to Dade County. Now, that is speculation. We have no idea where that occurred between Monroe County and Dade County. There's no reason to say it was on one side of the border or another. And I think that the state would like this to be like State Simmons, a case out of this court, I believe, that has a version of the standard like I like better, a violent presumption. But the evidence showed that the victim in that case, Ms. Tesler, was seen leaning out of a car in, I forget which county, Lake County, screaming for help. And her body was found in Lake County 2 days later. And the court said, well, you know, there's no indication whatsoever she was ever anywhere else. But that's not this case. We know that she was somewhere else. We know that she was in Dade County. The state knows that. The state knows it here. The state knew it below. And you all know that.
I mean, that's not, it says, well, it's possible that the murder could have occurred somewhere else. It's reasonable to infer. So I don't think Simmons is as firm as you're saying, and that it's nobody saw her anywhere else. It's possible. I mean, the case literally says it's while it is possible that.
Right.
So.
But there, that was the evidence. Was it possible? Sure, we don't know what happened in 3 days, but there was no indication. Here, it's not just possible. We have an open question. Is it possible it happened in Monroe? Yes. Is it possible it happened in Dade County? Yes. Do we have any way other than speculation to say it was on one side of the border or another?
I mean, don't you have to say, if we're going off of Simmons, don't you have to say that the jury was unreasonable, too? I mean, it's similar to the competent substantial evidence.
It was unreasonable under these facts to conclude that it was in one place or another. There was no basis, whether it's competent sufficient evidence, whether it's preponderance, whether it's a violent presumption. The evidence has to establish something. Here, the evidence was completely agnostic as to what happened. And as I say, unlike Simmons, there was a reason to think that she was somewhere else. We know she was somewhere else. At some point, the border was crossed, and you can only speculate, well, he must have murdered her in Monroe County, or well, he must have murdered her in Dade County. Could have murdered her on the Card Sound Road and been in both. I mean, had the option of both. And speaking of the option of both, the state, you know, this isn't a situation where it's unfair to the state, where venue cannot be determined. The state has, under the Constitution, the right to charge it just disjunctively. They can say, either in Dade or Monroe this happened. And that would be sufficient, but that gives the defendant also the constitutional right to pick which of those jurisdictions. And it's clear that the state did not want that. The state did not want this being tried in Dade County. The state wanted it being tried in Monroe County. Those of us who spent some time there all know that Monroe County is the longest small town in America. As I say, people all know the landmarks, and it's hard sometimes to talk about what they're discussing from a transcript. I wouldn't want to try murder like this in a small town. I want to try it in a big city. And you can bet, based on what we see, based on this strange decision to not charge it disjunctively, the state desperately wanted to try it in Monroe. I'll just point out that some of the arguments that, the state argued that she was dead at 5 a.m., hours and hours before she was dead near Long Key, and said there was no evidence to say to the contrary. But that's not the test. They have to say some evidence going one way or another. Maybe I'll address Juror Kinney next. The state struck Juror Kinney because she was a juror who had problems with the death penalty, but said she was open to it. The judge concluded, I think she had an absolute prejudice against the death penalty. And this is how the judge described what the duty of a juror was, that jurors need to be open to both sides if you're going to be on the jury here. And repeatedly what Juror Kinney said was, I can listen to both sides. She said that she was open to both sides 6 times. She, page 249, she says she opposed the death penalty, but I'm open. Same page, she said she would listen to both sides. She wasn't saying she couldn't impose it and would listen to both sides. Asked if she was reluctant, she said she would listen to the evidence, but not an eye for an eye. And on 261, she said, I want to hear from both sides. Asked again about whether she could impose the death penalty. She said, I have seen some cases where I thought it made sense. And I asked again if she could consider the death penalty as an appropriate penalty. She said yes. And again, the last thing she said when asked about this was, I could consider it. Now, the Constitution says you can't exclude somebody just because they don't like the death penalty, because that gives you a very skewed panel. And lots of people think that the death penalty is a bad idea, and some people think that it's contrary to their morals. This is someone who thought it was a bad idea because there was risk and because there was expense. And I believe, maybe you'd know better, there are plenty of judges in this state who feel pretty much the same way, but are willing and able, in an appropriate case, to issue a death sentence. The state says, well, the state seems to place some value on the fact that she was saying that it was based on things she had seen and heard and her concern for expense. But I don't see how it's harder to set aside those things based on what you've heard than your religious or moral values. And the cases say if they're able to set aside religious concerns, they can serve. And this court has said that jurors who say things like Chandler might go toward life or lean toward life. Farina, I have mixed feelings. I try to give the state a fair chance. And at the guilt stage, he would try to do what's right.
In this whole extended discussion with this prospective juror, there's just kind of equivocation after equivocation, expression of reluctance after expression of reluctance. It's kind of a theme going through it. Now, and she'll say, well, of course I have an open mind and things like that, but it is accompanied by all these kind of repeated expressions that could be characterized as reluctance and uncertainty and doubt about the death penalty. And we've got to decide that the judge abused his discretion here, and ultimately it's kind of a credibility determination. He's got to decide the issue based on his judgment about what she's saying, And this is not one where there's nothing to, it's hard for me to see how there's nothing here that supports what the judge decided. I understand you're focusing on things that might point them in another way, but when you look at the whole context, it seems like there's quite a bit there that the judge can be used to support the judge's exercise of discretion.
Okay. I think there's 2 points there I'd like to address. One is abuse of discretion. And I know the standard I'm up against, but the conclusion that she had an absolute prejudice against the death penalty, that's the basis that she was struck on, and that is what's not supported on the record. Take me to question 2. Was she just equivocating? No, she was expressing that she being honest with the court. They want to know what her opinions on the death penalty are. She gave them to them, but asked again and again, could you do it? She said yes. And, you know, in many cases, you have a juror in alt, like can somebody came forward with their opposition.
The state asked her, the state says, the concern that I have is whether you're interested in this area, having listened to podcasts and other people's opinions, but she had talked about that, or reports of these, as you say, botched executions taking place, whether that would cause you to be reluctant to impose the death penalty if you otherwise felt it was appropriate, based on the evidence and the instructions that the judge gave you. Then she says, I would listen to the evidence, and I can't tell you for sure, but I'm not the type of person that would say an eye for an eye or a tooth for a tooth. What do you say about that?
Well, the question they were asking was, can I tell you for sure that I'm going to give you a death verdict? And she can't. She says, well, I would have to listen to the testimony.
No, that's not the question. That's not the question. I read you the question. And you're saying that he was asking her, can you be sure you would give a death verdict?
Yes.
Well, counsel, did you hear what I read?
I heard what you read.
You think I misrepresented what he said?
I do not for a minute think you would misrepresent.
Well, I don't see how your characterization of that question is consistent with the text of the question that I read from the transcript.
We disagree. I think that it
we do?
And yes, Your Honor.
Read in the text of the transcript for me, the text that supports your characterization of the question.
I don't have the transcript before me for that.
We'll move on.
And at the end of the day, where she came down was that she could listen to both sides and give a verdict. You know, if you look at Bryant, that all you need in many of the court's cases, them eventually to say, well, I'll follow the law and I'll weigh. She said, I will weigh. And if you look at Deviney, we have someone who said automatically the death penalty, and then was brought back to say, I will, of course, follow the law, but then said, well, in the case of premeditation, it's death automatically. Now, I know that was a plurality opinion, but that's what this court, and I think I have the two sides of the plurality here, that is an indication of what the court is prepared to accept as
Counsel,
someone who can serve as a juror.
Could I ask that you move and address the sufficiency of the evidence for the HAC
Yes.
aggravator?
As before the jury,
Yes.
the proof was insufficient for this reason. The testimony from Steckbauer was that she would have been unconscious for when these terrible things were done to her. And
Well, it seems like he went back and forth.
he did, I would say, in terms of what he said in voir dire. He certainly said something that would have been sufficient. My contention is that what he said, I cannot say to a medical certainty if she was conscious or not. And he did go a little further after the voir dire and say, well, she would have become conscious for some part of the experience. And I don't know what that means, and neither does the court what he means by experience. We certainly don't know how long some part is. If I've answered the court's question, I think I'm well into my rebuttal.
Yes, thank you.
May it please the court, Michael Mervon on behalf of the state of Florida. I'll begin with venue. The state presented evidence from which a jury could reasonably infer that this crime occurred in Monroe County. Again, to repeat, counsel for appellant, the victim's body was found in Monroe County. She was a resident of Monroe County. Defendant was a resident of Monroe County. He dumped property in Monroe County. He washed his hands in Monroe County. There's no evidence she was ever in Miami-Dade County. Further, defendant admitted, or he stated, that she died in Isla Mirada, Monroe County. And although many portions of his statement the state would submit are not credible, and maybe all of it, if none, but the trier of fact, of course, can look at testimony and say, I believe all of this witness's testimony, none of this witness's testimony, or portion of it. And for purposes of sufficiency of the evidence, that supports a finding that there is, in fact, sufficient evidence to establish venue.
I'm just curious. Typically, venue is established by the prosecutor asking a witness on the stand, did this happen in Monroe County, Florida? And the answer usually is yes. How was venue presented in this case to the jury?
The parties stipulated that the body was found in Monroe County, and all of the other evidence. An officer wasn't asked explicitly.
Right. You didn't have that direct, but it just, so all you have basically is a stipulation that the dead body was in Monroe County. So as far as where the actual murder took place, you have to connect some dots.
Correct. And of course, on appellate review, we look to all the evidence and we take all reasonable inferences in support of the judgment and the sentence. And the reasonable inferences in this case, I would submit, support the conclusion that this crime occurred in Monroe County. As to the challenge to Ms. Kinn, veneer person Ms. Kinn, there was definitely a reasonable doubt whether she could be a fair and impartial juror in this death penalty case. The judge asked the panel as a whole, do any of you feel you don't have the correct characteristics of a death qualified juror? And he defined informally what that was. And she raised her hand and she said yes. There was later questioning of her, and I think her response was never say never. It was far from a definitive yes. And she vacillated, she went back and forth. She did express that in this case, I would be concerned if he were sentenced to death, that sentence or the execution might be botched. So that vacillation alone was sufficient to raise a reasonable doubt, and there was no abuse of discretion in that regard. Finally, as to the sufficiency of the evidence for the HAC aggravator, there was competent substantial evidence that the victim was conscious and aware of at least portions of this crime. She had marks on her neck which were consistent with being choked with a ligature. The medical examiner testified that she would have taken at least 45 seconds to lose consciousness after that began. This court has stated that the strangulation of a conscious victim is sufficient in some cases to support that aggravator. Also, she had signs
Counsel,
of...
let me ask you about this. Is there anything else in the evidence that points to the reason that she would have lost consciousness? Is that developed?
I don't believe it was. I mean, she did suffer catastrophic bleeding, but I don't believe there was any connection made between that and a loss of consciousness.
But there's nothing like, she was hit on the head, or no evidence related to something that would have rendered her unconscious before she was strangled, or before those devastating injuries were inflicted on her by the defendant.
No, Your Honor. In addition, the medical examiner testified that she had abrasions on her wrists, as well as lacerations and hemorrhaging to her mouth, both of which were signs of a struggle. So there was evidence that there was a struggle. And the medical examiner testified that these injuries took place or were inflicted within close proximity of one another. So based upon that evidence, the state submits there was competent substantial evidence that the HAC aggravator was proven. If the court has no further questions, we would ask that it affirm the judgment and sentence.
Can we circle back on the venue thing? So
Yes.
I think counsel on the other side said that the state's theory was that she went, that she was in Dade and then came back at some point, and you said that there was no evidence that she was in Dade. Could you just clarify that?
There was no evidence that she was in Miami-Dade County. The state did make arguments below attempting to explain a conclusion that rigor mortis was set at 5 p.m. However, the evidence was far less strong and far less clear as to when the body was found, when rigor mortis had set in. For example, the responding officer stated that he noticed lividity beginning to be observed in her breast, and that was sometime after 2 p.m. The medical examiner testified that the amount of time it takes for lividity to occur varies with each person, and that's dependent upon the amount of liquid within their body. There was no real testimony as to when her body was moved. And of course, we're looking at the evidence for competent substantial evidence, not necessarily the state's argument below.
Thanks.
Thank you very much.
I just want to address some factual questions that have come up during the state's argument. The state says that Ms. Osborne was a resident of Monroe County. That's far from clear. At the time, she was homeless in Monroe County. Homelessness is a sad condition, and many people are itinerant in those circumstances. But I accept that she was staying in Monroe County around that time. That residency does not establish where the crime happened. It might help suggest the theory that the state argued below, that Mr. Wolf picked her up and at some point along the way decided to kill her, but we don't know where along the way. Residency doesn't speak to that at all. The state says there is absolutely no evidence that she was in Dade County. Well, under that new theory, the state is saying she wasn't in the van when it left Florida City, very much contrary to the position at trial. He picked her up in the 1.5 to 2 hours he had, or the 1 hour and 50 minutes, and then committed these crimes, and then went to Vaca Cut. The state says, well, there was a stipulation that that's where the body was found. Yes, but it's just like residency. The whole question we have is, what is the venue for the crime, not for where Ms. Osborne's body was found. The state also points to the livor mortis question, saying, well, the police testimony is contrary to Dr. Steckbauer. It's not. There was testimony, as the state says, that there were signs of liver at the beginning. That is what Dr. Steckbauer said could happen. He says, it can start almost immediately. Livor mortis is, the settling of the blood within the body after somebody dies. But it does not set until much later. It sets beyond the 6 hours, closer to the 12 hours. And it's based on that testimony, which is not undercut by the police officer's testimony, that we know she must have died long before the van entered Monroe County. And working on the principle that you don't have to keep talking when you have nothing else to say, I'll ask the court to reverse, remand for a new trial in the proper venue, or in the alternative, a new penalty phase.
Thank you. Okay, our last case for today is Saffold versus State of Florida, number 2023-1749.
Good morning, Your Honors. May it please the Court. My name is Tim Wang, and I represent the petitioner, in this case, Jeremy Saffold. I previously requested 4 minutes of my time for rebuttal. Before this Court is a certified conflict between the 4th District and 2nd District Courts of Appeal regarding what procedural rules apply where a sentence is reversed for a resentencing hearing, where the original sentence was reversed after an appeal or vacated following a post-conviction motion. In this case, petitioner moved to withdraw his plea prior to a resentencing hearing in a case I'll refer to as Saffold 1. After the motion was denied and he took a second appeal, in Saffold 2, the 4th District Court of Appeal held that petitioner was not allowed to file such a motion under Florida Rule Criminal Procedure 3.170 subsection F, because that rule only applied to motions filed before the original sentencing hearing and not any subsequent resentencing hearing, and certified conflict with the case called Scott from the 2nd District. Petitioner asked this Court to disapprove of the 4th District's opinion in Saffold 2 for the 3 reasons outlined in my briefs.
Counsel, can I ask you, if we were to say that the second was generally correct, that a motion to withdraw a plea would be allowed, what would be the limitations on that, procedurally?
Procedurally, I believe it'd be the same limitations, or if there are any limitations at a original sentencing hearing. The rule doesn't make any exceptions or makes any differentiations between a resentencing hearing and an original sentence. Obviously, the only
but there's still a judgment and conviction that remains, correct? That doesn't get vacated on a resentencing.
If the conviction at a resentencing, correct. If it's not challenging conviction, obviously, yes.
Okay. So could, let's say, a defendant challenged his conviction, it was upheld, but it was sent back for resentencing. Would he be able to withdraw his plea?
I believe at that point, yes, just the way the...
So he gets another chance. He lost on appeal, but he gets another chance under a procedural rule.
Correct. The procedural rule doesn't make any differentiations between a resentencing hearing and a sentencing hearing, the original sentencing hearing.
Right, but we look at these procedural rules as a whole. We have a lot of rules on finality, on time bars, a lot of time is spent on that. So the way you're asking us and the way kind of your brief lays this out, and I think the way the second, arguing the way the second did, it's very broad. It essentially gives no limitations on when that would come into play at resentencing. And do you understand that that could cause issues?
Any procedural rule where a defendant is asking for some type of relief could obviously cause issues. The question before this Court is whether a defendant is entitled by the rule to make this type of motion at a resentencing hearing. Now, the rule, Florida Rule Criminal Procedure 3.020, requires that rules be construed for simplicity in procedure and fairness in administration. And so while the rules obviously, at a resentencing hearing, I think Your Honor is asking whether there should be any limitations. I don't believe there is. If we are interpreting the rules for simplicity and fairness, we shouldn't be treating a resentencing hearing any different from the original sentencing.
So let's say that fairness is the consideration, because I think the rules we write rules in the context of background principles of law, including the limited nature of a trial court's ability to address cases on remand. But if the point of a plea is to obtain a conviction, the basis behind, the justification behind allowing defendants to withdraw pleas is that to protect the right to jury trial. That right is still protected if the plea is affirmed on appeal or not addressed, and then the narrow issue of the sentence is reconsidered. So, I mean, we kind of have to pull, like, your textual argument is very literal, and it pulls everything out of the background principles of law that this operates within.
I would argue that when we affirm, I mean, this is obviously a case involving a plea, so I imagine there's going to be very few cases where someone's appealing a plea and is also challenging his conviction. However, even if there is a situation like that, the question is not whether he's challenging, whether he's allowed to challenge the conviction. He's arguing whether there's good cause to establish, that he established in withdrawing a plea. In this specific situation, he's arguing that his plea was involuntary. That's also a right that he's entitled to argue out of resentencing hearing.
Would they be able, under your theory, be able to argue good cause that they could have argued the first time on appeal, or is it just good cause related to some new issue in the resentencing?
I'd argue it'd be any type of, the rule doesn't limit when good cause
So
occurs.
everything we've ever said about, you have a chance to argue, and if you don't, it's waived, this one rule just eliminates that under your theory.
The only limitation that the rule provides is that the motion has to be filed prior to or before the sentence.
Well, look, I'm glad you used the definite article there. So let's talk a little bit about the usage of articles in this rule. When you look at 3.170F, your argument essentially is that in the phrase before a sentence, the indefinite article A should be read as any. Okay, which, by the way, is a choice we or others, when drafting the rule, could have made. It could have said any. Instead, it says A. Then if you turn to 3.170L, it says, it refers to the sentence. It says, a defendant who pleads guilty or nolo contendere without expressly reserving the right to appeal a legally dispositive issue may file a motion to withdraw the plea, singular, definite, within 30 days after rendition of the sentence. So reading the rule together in pari materia, isn't it more reasonable to read that A not as any, but as a single transaction that the rule is contemplating as the sentencing? Like, stated differently, if F said the sentencing instead of a sentence, wouldn't you agree that you're out of luck?
No, Your Honor. My argument is that there could only be one sentence for every offense, obviously, a person's convicted of. So it is singular and has to be singular. The use of the term any is going to open up the doors for a defendant to file a motion to withdraw plea, really, literally on any sentence, even an unrelated case. So
I guess what I'm saying is you have imported into this indefinite article something that it will not bear given the text of the rule as it stands altogether. That seems to be my point. And it seems like you're almost conceding that. It seems like you're saying, yes, I mean, this does sort of, this rule, 3.170, as a whole rule, envisions one sentencing, not any sentencing.
Correct. The sentence that's being, that he's filing a motion to withdraw from the plea from. So I agree with that in that sense. Okay. I believe the article the is being used in the other subsection L, because A is an indefinite article, like you mentioned, and prior to a sentence, it's just more grammatically precise to use the term A because there is no sentence that you're identifying in this.
Or it's being used, or the whole rule is speaking of the sentencing, which, I guess my point is, do you concede that if it said the sentencing instead of a sentence, you would lose?
No, I don't believe in that.
Why not?
I believe there is only one sentence, whether you use the article A, whether you use the article the. The only reason there is differences in the subsections is because the sentence hasn't imposed prior to the sentence, obviously, and after the sentence has been imposed, a definite article the is being used. It's just more grammatically precise, but it doesn't limit that a resentencing hearing is any different from the original sentencing. This court has held, and the district courts of appeals in Florida have held time and again, that de novo resentencing process begins the sentencing process all
Well,
over
but
again.
the principle invoked there is it has no bearing on the issue here, because the principle there is that when you go for a resentencing, you get to bring in things that are relevant to the sentencing. You kind of start on a fresh slate with how the sentencing is going to proceed. This is about the conviction. It's not about the sentence. And so basically you're asking for a de novo aspect on this on the conviction, which is not what that law is about at all. Tell me why I'm wrong about that.
I'd argue that when a case is set for de novo resentencing proceeding, you're taking the defendant back to a point in time prior to the error occurring. If that's how we're treating a de novo resentencing,
But that's not consistent with the way we have described the operation of de novo of resentencing. I just don't think, if you look at the language that even you quote, it doesn't carry that implication. It's focused on things that are relevant to the sentencing, not things that are relevant to the conviction.
I would argue that when a de novo resentencing is ordered, it's not just you're not asking or mandating the trial court to just conduct a de novo resentencing. You're also vacating the sentence. And that is what the other states that I've cited to you in my reply brief have held. A void sentence or a vacated sentence is essentially no sentence at all and hasn't been imposed yet. Therefore, the pre-sentence rule should
But again,
apply in
that's
that
different
case.
from the conviction.
I understand, but the other states have held that because it's a void sentence, and therefore when you send the defendant back for a de novo resentencing hearing, it begins the process anew as if there is no sentence, and therefore the pre-sentence rule should apply.
I think the question is, what process does it begin anew? And I think the state's argument is it doesn't begin this entire period that existed in sort of a pre-initial sentence phase, which is what you're saying. You're saying it just kind of starts it all over. For instance, let me ask if you agree with this. Can he withdraw his plea as to issues not remanded, as to counts? Because that's the case. It's only remanded, I think, as to 2 counts, correct? So what about all the other counts?
My position, petitioner's position, is that the mandate in Saffold 1 remanded the entire case for resentencing on all counts. I understand the state's taking the position that it's not, and obviously the Saffold 2 does not say that as well. But the parties below all believe that this is a resentencing hearing. The trial court entered a resentencing order. After the resentencing was conducted, she entered new trial sentencing documents on all counts, not just the 2 that were that the state argues was only set for resentencing. So on appeal, the parties also never argued in Saffold 2 that that only 2 counts were set for resentencing, and therefore it doesn't get relief on the others. So it's petitioner's position that the parties below, the parties on appeal, all agreed that this was a resentencing mandate from the court. So, but as to your, Justice Kennedy, your question about it only affects the conviction, the procedural rule, the plain language of procedural rule is pretty clear. It says that a defendant, the trial court may, within its discretion, or shall, upon a showing of good cause, permit a defendant to withdraw a plea at any time before a sentence. And the key operative word in this case is before a sentence. The state's arguing that a resentencing hearing has to be treated differently from a sentencing hearing. There's no other rule provided by this court or in the statutes that treats these 2 concepts differently. And that, if it did, it would be contrary to the Rule 3.020, which states that the rules have to be read for simplicity in procedure and fairness in administration.
I'm not sure.
Well, but the fairness of administration, your invocation of that point kind of mystifies me, because it just seems to cry out here that there would be great unfairness in the administration of the rule and the way you're suggesting to the state. Because the idea that someone 10 years later, when witnesses may have died, or the state's ability to prove up the case may have gone away, when the state could have easily proved it earlier, that somehow they could do that. And I guess that is, I'll just make that and let you respond to that. But along with, why wouldn't we just understand this rule about plea withdrawal, it really is kind of setting time limits on the withdrawal of the plea in these two different ways. And, you know, one, under the second rule, it's about to avoid, to deal with issues that could be dealt with otherwise on appeal. So you don't, you know, you deal with them as soon as you can, okay? That's what that rule is about. And the first rule is kind of giving a safety valve for after the plea is entered to allow potential regrets or whatever that would, you know, get over the hurdle and to convince the judge to allow the withdrawal. But it's time limits on that, which just have make no sense at all in the context of a resentencing, because the ship has sailed. The time limits have passed.
So my response to, I guess, the latter part of your question is that there are no set time limits. I think what you're suggesting, the Saffold 2 has suggested, is that maybe there should be time limits, but the rule the way it's read now does not have such time limits. To answer the first part of your question about...
Well, we'll see.
To answer, correct. But to answer the first part of your question, the fairness in administration also deals with what procedural rights a defendant is allowed to raise prior to the resentencing hearing. In this
but how
case,
is it fair to allow someone to withdraw a plea when the state would be, in many cases, prejudiced in a devastating way by this long delay?
There's nothing in the record below suggests that the state was prejudiced. No argument was made, no evidence.
But you're asking us to make a rule that applies to all the cases from here on out about withdrawing a plea. So this court orders in a 25 years after a plea in a death case, and he decides to withdraw his plea, I mean, that's going to be equally an issue there. So why is this, I mean, focus on the question here is why is this not an issue as to the finality for the state?
It's not an issue as to finality, because the purpose of the principle of finality is to ensure that at a certain point the litigation must come to an end. I believe that's how it's defined in Witt versus State. In this situation, it's different from Campbell, which the Fourth and the state relies on heavily. The litigation obviously is not coming to an end. When his case is set for resentencing, he's going to argue for a departure sentence, a lower sentence. After sentence over, he may file post-sentence motions. He might file post-conviction motions. He may file a third appeal in this case. Clearly, the principle of finality is not going to be an issue because the case is still being litigated. As to address some of the concerns about the fairness procedure, good cause still has to be established before someone could withdraw a plea. If a defendant on remand files a motion to withdraw the plea and argues that I participated in the first sentencing and I am afraid I'm going to get the same sentence or a worse sentence at a resentencing hearing and I'm withdrawing my plea, I'd venture to say that's not good cause. And so I believe, obviously, the way the rule is set up, it's a defendant has to establish good cause. It has to be substantiated, and it has to also be granted by the court. So I see I'm into my rebuttal time. Unless there's any other questions, I'll reserve my time for rebuttal. Thank you.
Thanks. So can you take a position on the Coriel versus Sasso debate? Can this be decided on a kind of literal reading of the four corners of the rule, or do we have to resort to background principles in order for you to win?
I think it could be one on both the literal reading as well as the background reading.
She chooses to take no position.
But under both circumstances, first, I agree with you, Justice Coriel. The statute 3.170 demarks time. It's a demarcation in time. And you can look at the language and it says a sentence in 3.170F and it says the sentence in 3.170L. If you juxtapose that to the statute that was referred to by petitioner in his brief, 3.700, which is in the portion of the rules on sentencing, there is no article in that, despite both of the rules being adopted in 1968 at the same time and amended again in 1972. The A was adopted by this court and added from the predecessor statute, which I believe was 909.13. So A is there for some reason, and it is to mark time. And the point is that when there is a vacation of a sentence and a resentencing, that doesn't mean that the original sentence did not occur in time or that the defendant did not previously have the opportunity to raise the claim.
So you think that he's basically kind of overreading the principle that he's saying you can read our cases as saying that the effect of a vacator of a sentence is that it's as if it never happened. Like we can literally just sort of drop the defendant back in time to where he's pled guilty, nothing, there's been no sentence, and we just look at a sentence. So I don't have a sentence, and so I have all the rights that I had before. And you're saying that that's not really what the principle that we've established isn't that broad.
That is correct, Your Honor. When there is a void sentence, that doesn't mean that procedural history didn't occur. In other words, that didn't mean that a fact occurred in time. It simply means that procedurally, you no longer have a sentence and you're going to de novo resentencing. And as to Justice Kennedy's point, when you're in de novo resentencing, you're looking at issues that bear on the appropriate penalty. You're not looking at issues that pertain to the underlying conviction. You wouldn't do that if you were convicted after a trial. So it is different, and just because something was void doesn't mean that it didn't happen in time. The acceptance of the plea does constitute the conviction. And once, this court has always insisted that issues be raised at the first opportunity or they be waived. The text of Rule 3.170 as a whole circumscribes that time for a defendant to contest a plea and assigns a greater burden for doing so after sentencing. And that is where Justice Grosjean, the history of our jurisprudence comes into play. Because when you look at Harrell, this court specifically stated that sentencing is the critical juncture for purposes of withdrawing a plea. And then in Campbell, this court stated that that to look at 3.172, you have to do that harmoniously with 3.170F in para materia, which it did. And it decided that even if a plea has not been formally accepted by magic words by a trial court at the time of the original sentencing, that plea is deemed to be accepted. So this court has already established sentencing, the original sentencing, to be the critical juncture. And I'd ask this court what would happen if we did accept petitioner's argument. Would the sentence then be deemed unaccepted? And in circumstances, for instance, like in Campbell, where there was no formal acceptance of the plea, would it then be deemed unaccepted because we're back at resentencing? Because you can only define sentence in the statute in one way. If you look at the language that petitioner would like you to seize upon in Rule 3.700, that focuses on the procedure, the sentencing procedure. It specifically says sentence, no A, is the pronouncement of a penalty or judgment of penalty. The definition provided by the state from the dictionaries does it backwards. It is the judgment entered on the pronouncement of a conviction. So again, stressing that the language that was adopted by this court was to focus on time and not procedure.
Can I ask you, they have brought up that many or some district courts have found that 3.170L applies after resentencing. Does the state have a position on if that is correct?
Your Honor, I would say that is not correct, and I would say if you look at what happened with the litany of cases that occurred, it started with Fox. And Fox was out of the 4th District, and in that case, it was 3.1800C, a mitigation. And the court went to some lengths to describe what a mitigation is and to say that it is not a rendition of sentence. That being the case, they decided that 3.170L did not even come into play because specifically in the language of that subsection of the rule is the term rendition. And they compared that to the de novo resentencing process. Then we moved to Pacino. And Pacino, the only explanation that was given was a citation to Fox and saying this is part of the de novo resentencing process. Then we go to Chipman, and Chipman, which really had to do with a jurisdictional issue for that court, stated, well, again, see Pacino, see Fox, and parentheticals referred to the de novo resentencing language, and then we get to Scott. And Scott, they
So
relied
it's really your position that 3.170 as a whole is off the table in a resentencing, because that is a procedural set of rules that occurs in time before a sentence is rendered. Then something goes up on appeal, there's a remand for resentencing, but we don't go back to this time period or this section of the rules. If on resentencing there were to be an issue, it would either be an appeal of that sentence or post-conviction.
That's correct, Your Honor. And I point to this court's language in Griffin, and in Griffin, they specifically rejected the defendant's argument that 3.170L is not jurisdictional. And in addition, they said, this court stated that if you don't file that motion within 30 days after the rendition of the sentence, then your course of action is a post-conviction relief, either in Rule 3.850 or Rule 3.851. To allow a motion to withdraw plea on resentencing would lead to absurd results, as pointed out by some of your honors. And I would like to stress that within the plea context, you don't have prior trial testimony. And often, because the plea can occur even as early as the arraignment, you don't have, the state has not developed its case. So that does mean that there might be witnesses that are no longer available, that we haven't obtained their contacts, and we don't have the same kind of evidence portfolio that you would if there was remand for a retrial. If there are no further questions by this court, I would ask that you adopt and approve the language of the Saffold case and quash the decision in Scott. Thank you.
Thank you.
Excuse me. I'd like to address one of the issues that has come up in this argument in terms of the unfairness to the state because of this procedure. The passage of time is not the only concern when it comes to the principal finality. Cases such as State versus Fleming and State versus Monaga, which came from this case, obviously dealt with situations where a case occurred decades ago, and then decades later, a change in the law has developed. And in Monaga, specifically, which happened recently, the state was entitled to impanel a jury to make these findings. I understand the point that there's a difference between conviction and a sentence, but in Monaga, the finding that the jury's asked to find was whether the defendant actually killed, intended to kill, or attempted to kill someone. That's akin to a jury finding. And so I understand what the concern is, but if the remedy for Monaga could be given to the state, the same remedy, the same, this situation, he's not going to be prejudiced in this regard. So in terms of the rules regarding resentencing, there is no separate procedures when it comes to a resentencing hearing in the rules or in the statutes. The state's position is that maybe there should be. But if we are now reading that subsection F, resentencing does not apply to subsection F, but it may apply to subsection L, it's not going to be read for simplicity and procedure, because at every juncture where the term sentence is being mentioned, a defendant's going to have to question, and the judges and the parties are going to have to question whether a resentence is going to apply in this situation or that. Regarding whether regarding Campbell, the state mentioned relies on Campbell, and the 4th District also relies on Campbell extensively regarding the principal finality. The key difference in Campbell is the fact that in Campbell, the defendant moved to withdraw his plea under a different rule altogether, but moved to withdraw his plea 11 years after the fact. The litigation at that point was over. In this case, the litigation was ongoing. At a certain point, the defendant may file a post-conviction motion. He may file a third appeal. there is no guarantee in the principle, there's no finality in an unfair sentence or unjust sentence in this case, and he's allowed to do so again. So I see that my time is almost running up. Unless there are any other questions, petitioner requests that this court disapprove of Saffold 2 and approve of Scott in the 2nd District. Thank you.
Thank you very much. We're adjourned.
All rise.